I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. It seems like you're practicing law from the bench. I'm going to respect your courtroom, but I disagree. Yes.
Sir, you have to stop interrupting.
Penalty and perjury.
If you stop speaking when I'm speaking.
Your Honor, he's coercing. And since there's no statute of limitation for fraud, he's wasting judicial resources. Honor my counterclaim to dismiss this matter.
So based on the proofs on the record, the court does find that.
All right, everyone. Today, we're looking at one of the most difficult sovereign citizen cases I've seen in a long time. Judge Hillman tried a very patient approach instead of shutting things down right away, which makes this hearing interesting to watch. But honestly, it raises a real question. At what point should judges stop spending time on arguments that go nowhere and simply move forward with the rules of the court?
You said I'm driving a vehicle. Yeah, you need me to stop? I
need you to stop, sir. I can't have you driving while you're.
15 seconds, I can pull it back up to my family house.
No, I can't allow you to proceed while you're driving a vehicle.
No, I'm saying I'm parked. I'm pulling up parking now. I'm parking, right? 5 seconds. Okay, I'm done, Your Honor.
You recall in reviewing your business records if a foreclosure was conducted with regard to this property?
Yes, it was.
Objection, Your Honor, hearsay.
Okay, overruled. You may respond, sir.
On what grounds? So I could maintain the error for the record when I appeal this, if this don't go accordingly?
Okay, it's a business record, sir. That's an exception from
first-hand knowledge. Was he there at the closing table?
Doesn't need to be, sir.
Your Honor, it seems like you're practicing law from the bench. I'm gonna respect your courtroom, but I disagree. I disagree. It's tremendous. So, okay. Court reporter, can you please note that the honorable judge, I'm stating he's practicing law from the bench without facts.
But your objection is part of the record, sir. All right. You may continue, Mr. Dooher.
And is this a true, correct, and complete copy of the sheriff's deed of mortgage foreclosure, to the best of your knowledge?
To the best of my knowledge, yes.
And is this sheriff's
objection, Your Honor? Can he vow to that under penalty of perjury? That's the original document.
Your Honor, he stated this to the best of his knowledge.
No, under penalty and perjury, can he contest that that is the original document with the wet blue ink signature? Penalty and perjury.
All right, sir. That's not the question. The question is whether he can identify the document.
Under penalty and perjury, can it be yes?
Sir, you have to stop interrupting.
Penalty and perjury.
You can make an objection, but once you've stated your objection, you have to stop.
Yes, Your Honor.
All right.
And for the record, Your Honor, I do have counsel coming for this next court date. They obtain as soon as he get back in the country, he will be jumping in to take care of this matter further. So I'll ask if you just give my counsel some time before any permanent decision is made, so they can review these books, all interrogatories, so we can make a fair decision. Because I'm not arguing it's a debt, and I've been trying to honor the debt, Your Honor. I'm not arguing that it's a debt. I done did everything possible to honor this debt. They have not been in compliance with it.
And Your Honor, I would object to that, given this would be our third hearing, and he had ample time to get counsel.
Objection again.
All right, let's take one issue at a time, gentlemen. I can't be expected to remember 3 or 4 objections all at the same time. I'm going to overrule the objection on the basis of a business record exception. As to the request to adjourn the matter for Mr. Bay to retain counsel, I'm going to deny that request. Mr. Bay is
on what grounds, Your Honor? Because I never got served directly.
If you stop speaking when I'm speaking, then I will state my ground.
Let's jump in and see how the situation unfolded. The main issue I notice in these types of cases is that many judges are almost too patient. Judge Hillman seems like a genuinely calm and respectful person, but this situation really called for firmer control. The man in the hearing was clearly stretching things out and taking advantage of the judge's patience. By this point, most people would expect at least a warning about courtroom procedures. It's frustrating to watch someone delay the process on purpose. Tell me what you think. Should the judge have stepped in sooner?
And so
I never requested that. You stated that, Your Honor. This is my first time requesting any adjournment to bring in incredible counsel who can handle this matter fairly on my behalf.
At this point, I don't even see that you have standing to participate in this case, although I guess we will get to the proof on that issue. So,
so Your
objection.
Honor, you don't have my deed of records right there. You don't have me as the deed owner. You don't have me as a certificate owner in the record. I put all that on the record. So for you to say I don't have standing is kind of unfair from my understanding.
And was that redemption date September 27, 2021?
Your Honor, he's coercing. He's coercing Mr. Dewhurst.
As a government record and or document recorded with the applicable recorder of deeds for this this document.
Okay. Any objection to that, Mr. Bay?
Absolutely objection.
Okay. And what's the basis for your objection?
He's a third-party debt collector. He's not a real party in interest, and he has no first-hand knowledge of any of the affairs that took place with this mortgage or at this closing table. And that Mr. Dewhurst he's not eligible to bind a corporation. Do he have the status of a CFO or a CEO in that company?
Okay, so the objection is that this witness doesn't have the
first-hand knowledge to any other matters.
Okay, all right. So the objection is overruled.
And has Carrington ever conveyed any of their ownership?
Objection, Your Honor. Objection.
What basis, sir?
Rightful owner as the title, rightful owner as complete ownership of the property. Can't just take away my interest like that without facts. You guys still have not had no verification of debt. What you have in your hands, Your Honor, we don't reached out. They cannot verify that debt, and they cannot verify that they ever loaned Rachel Brown and Matthew Brown any money for this mortgage. They can't. They can't prove that, and they haven't yet. And I've been waiting. I just want to know if they're a real party in interest, are they a real creditor in the amount, so we could handle any financial obligation if they are yet to prove that. Like you said, I got the deed, and it's sealed by the county records. I have the warranty deed as well, and it's sealed by the county records. Objection. Can you prove I didn't redeem and attempt to redeem? Can you prove that it hasn't been corresponding and negligence on you guys' behalf?
Overruled.
The property was foreclosed on and Carrington took control of it.
Okay.
Objection, Your Honor. How can you take control over something?
Another thing that makes this whole hearing confusing is why this man decided to represent himself. His case involves something as serious as losing his home. Yet instead of hiring a lawyer, he chose to repeatedly raise objections without understanding the law. That's exactly why the right to an attorney exists. Laws are complicated, and learning bits and pieces online isn't the same as legal training. I honestly don't see any scenario where self-representation would help him here. What do you think? Can you imagine this working out well for anyone? At this point, I'm surprised no one insisted that he get a lawyer. The judge kept things calm, but the repeated objections.
I got the taxes in my name. I've been staying there the last year, and I have the deed and the warranty deed again for the record.
May I ask a question that would help?
You may, Mr. Johnson.
Objection, Your Honor. He's about to coerce him again. The question was clear. He could answer that on his own.
Okay.
He said he had 30 plus years of experience. This shouldn't be his first rodeo. He can answer that on his own.
Was there any redemption made by any party during that time?
No.
And none of your reflect.
Objection.
None of your record.
Objection.
And once again, you have not.
What's your objection?
That's not
Mr.
credible.
Bay?
That's not credible.
Sorry, this is not your time to ask questions, Mr. Bay. Mr.
Okay,
Johnson.
let me know when I'm credible to ask questions.
All right, Mr. Johnson. Any other questions?
Has Carrington ever conveyed ownership of the subject property to any party?
No.
Thank you. No further questions, Your Honor.
Objection, Your Honor. Matthew Brown, not the owner at the time that they
Mr. Bay, this is your time to ask questions. So if you want to ask any questions to Mr. Dewhurst, you may ask questions to Mr. Dewhurst.
Okay, Mr. Dewhurst, is it not law that 15 USC 1692G requires verification of any debt?
Your Honor, I object as to relevancy.
Again,
okay, what's the relevancy, Mr. Bay?
I'm establishing bounds for fraud. And since there's no statute of limitation for fraud, I'm going to make sure if they're not the original creditor, that it's fraud.
You didn't respond to the relevancy or how this is relevant.
The relevancy of 15 USC 1692G, it binds any corporation or anybody who's saying there's a debt or a balance to verify it.
Okay, So this is the time to ask questions, not to argue law.
No, I'm not trying to. I'm asking a question. That was a question.
You have a question regarding the facts for Mr. Dewhurst. Okay, you may proceed.
Yes. So again, Mr. Dewhurst, under 15 USC 1692G, do you have to verify a debt?
I'm going to have to object again regarding relevancy, Your Honor. This is, unfortunately, he does not have standing to bring any claims of verification.
Objection. I'm a real party in interest. Objection, Your Honor. He doesn't have any standing. He hasn't proven he's more than a third-party debt collector yet.
Your Honor, after the foreclosure period ran,
Your Honor, we don't know if this is credible foreclosure. Can I ask my questions, Your Honor?
All right, gentlemen, you cannot speak at the same time.
Next question. So, Mr. Dewhurst, are you conscious of the verification of that letter that been sent to your company twice that I sent with behalf of Matthew Brown and Rachel Brown that they're yet to respond from? My notary sent it. The Notary Republic sent it. Your Honor,
I would have to object.
Yes or no?
Sir, you have to let Mr. Johnson state his objection. Mr. Johnson, what's your objection?
Your Honor, she's asking the witness to respond to a vague request if he has any notice, but I would ask that he would only ask as it relates to the business records, Your Honor.
Objection, Your Honor. I sent that to the Business and Record Department, and I sent it attention to the CFO of the company.
That's an argument. That's not a question. This is a time for questions.
Many of which didn't apply. We're stopping the entire hearing. Court rules exist so the process can move forward. And when someone keeps interrupting without reason, it becomes impossible to settle anything. It really seems like he either needed guidance from an attorney or a hearing to determine if he understood what was happening. Would you have paused the hearing here or continued letting him talk? Then things took an even stranger turn. The man claimed the plaintiff was wasting the court's time, even though he was the one slowing everything down. Everyone in the courtroom, from the judge to the attorneys, was waiting on him because he wasn't following procedure. This is something we see a lot in sovereign citizen cases. People talk about their rights.
That was in the form of a question. You didn't let me finish, Your Honor.
Okay, well, you can't ask multiple questions within the same question.
Okay. Well, Mr. Dewhurst, what was the problem answering the verification of that letter? If you have that in the record. So we've been asking for the original.
Objection, Your Honor. He stated that he was not aware of a letter.
You're right. Correct. So I should say then, moving forward, is there a problem producing the original contract with the wet bluing signature from Rachel Brown and Matthew Brown? If you have that in the records.
Okay, so you have a question for Mr. Dewhurst?
Yes, Mr. Dewhurst. Is it fair to say you cannot prove that the original, you don't have access to the original copy of the note of the mortgage?
Yes,
under penalty and perjury. Do the company have it, Mr. Dewhurst?
So you may ask another question.
And okay, also, Mr. For you, Your Honor. So it's also credible and fair to say he has no firsthand knowledge of anything as well.
Okay, so that's an argument. That's not a question. Okay. So yeah.
All right, I'm learning. I'm sorry, Your Honor. Thank you for your patience. So Mr. Dewhurst, under penalty and perjury, can you confirm that your company followed all gap procedures with this process?
Objection, Your Honor.
So I guess the last question, again, I just want him to confirm that Mr. Dewhurst, you have no firsthand knowledge of the of Carrington Mortgage being a creditor in this loan for this mortgage. So that's still kind of broad, Your Honor. I want for the record for him to say, are you guys the creditor, or you don't know?
Asked and answered.
No, that's not asking and answer. I'm asking directly. Mr. Dewhurst, is Carrington Mortgage, can you confirm they're the creditor of this loan or this note, or you don't know? And I'm asking that for lawful reasons.
And so by bidding the highest in the sheriff's sale, what interest does that give Carrington then in this proceeding?
We're then the creditor.
Okay. All right.
Allegedly. So that is true if that's the case. But if, Your Honor, or court, if Carrington can never prove they ever issued anything, is it fair or is it lawful to state that they never have the right to say they hit with the highest bidder with anything?
Any more questions for Mr. Dewhurst, Mr. Bay?
Not at this moment, Your Honor.
Okay.
Not at this moment. I'll let my counsel deal with that.
Okay. Does the plaintiff rest?
Yes, Your Honor. But if I may just conclude with a couple things, if that's okay.
Well,
objection, Your Honor. Statement and brief from counsel is sufficient for summary judgment.
And to show that there was indeed a foreclosure sale conducted on March 25th, 2021.
Objection, Your Honor.
And this is final argument, so that you can't object to that.
I'm sorry, Your Honor.
All right. Additional final state arguments, Mr. Bay?
Yeah, again, Your Honor, you know, he's wasting judicial resources.
But forget that the legal process comes with responsibilities too. Delaying a case doesn't make it disappear. Do you think he was confused, or was he trying to buy time? And then, just when the hearing seemed like it couldn't get more complicated, he insisted he would simply appeal the case and get it overturned easily. But appeals don't work like that. An appeals court doesn't give you a redo. They only review whether the law was applied correctly. Unless a judge genuinely ignores the law or violates rights, nothing gets overturned automatically. For me,
coming with this because, again, I have proof on file and on record, correspondence. We try to resolve this matter. At this time, I would like to bring my counsel in. They'll be back in the States in a couple weeks. And also, Your Honor, can I request that Mr. Johnson put his bond on file? Can I get his bond information, his liability bond for this matter as well?
Okay, no, that's not an issue in this case.
I ask for you to just honor my motion, honor my counterclaim to dismiss this matter, because they don't have, it's not a, nobody with real party and interest on this line right now. Nobody with firsthand knowledge is on this court case right now that can speak and contest to what's going on. So with that being said, I ask to adjourn this matter or dismiss this matter because for failure to state a claim upon which relief can be granted.
An individual who's identified himself by the name of Amate Bay claims to have a possessory interest in the property, though he did not present any proof on the record today of any interest that would make him have standing to contest this mortgage foreclosure and this suit for possession. So based on the proofs on the record, the court does find that Carrington Mortgage Service, LLC, does have the right to possession, and therefore a judgment of possession against Amate Bay and all occupants of the premises is granted.
What is my time frame to no, can you just for the record, so there's no contract with Amate Bay and Carrington Mortgage in this matter, right?
Sir, I'm not going to explain my ruling to you. I just ordered that the Carrington Mortgage would have the right to get an order of eviction, removing all occupants from the premises.
That's fine, Your Honor. I'll make sure it get overruled in a higher court. Thank you.
Okay. All right. That's all for the record. Thank you, gentlemen.
Thank you,
Your Honor.
This hearing was a perfect example of what not to do in court. Even though I think the judge could have been firmer, his patience was impressive. But the law doesn't change just because someone refuses to accept it. Sovereign citizen arguments don't replace real legal procedures. So I'll wrap it up here. Let me know in the comments what you think. Was he truly confused, or did he believe he could win this way? And if you enjoyed the video, make sure to like and subscribe. I upload new content every day. Thanks for watching. Take care.